Good day, everyone. Today, we will discuss the salient features of early advisory opinion from 1948 to 1956. I am Maria Anianong, and along with me are my group mates, Ms. Shara Maylan Shan and Sir Demosthenes Libera. So, this report will be divided into three portions. So, the first part will be the first four advisory opinions from 1940 to 1956. So to start, let us define an advisory opinion. An advisory opinion is a legal advice provided to the United Nations or a specialized agency by the International Court of Justice in accordance with Article 96 of the UN Chapter. The General Assembly and the Security Council may request advisory opinion on any legal matter. Other organs and the specialized agencies may request advisory opinions on legal questions arising within the scope of their activities. So, in general, advisory opinions are not binding, but may inform the development of international law. According to the ICJ website, advisory opinions carry great legal weight and moral authority. They are often an instrument of preventive diplomacy and have peacekeeping virtues. Advisory opinions also, in their way, contribute to elucidation and development of international law and thereby to the strengthening of peaceful relations between states. So, the first advisory opinion from 1948 is the conditions of admission of a state to membership in the United Nations, which discusses Article 4 of the UN Chapter. So this case was decided on May 28, 1948. Resolving the issue is a member of the United Nations which is called upon in virtue of Article 4 of the UN Charter to pronounce itself by its vote either in the Security Council or in the General Assembly on the admission of a state in the United Nations juridically entitled to make its consent to the admission dependent on conditions not expressly provided by paragraph 1 of the said article. So in particular, can such a member, while it recognizes conditions set forth in that provision to be fulfilled by the state concerned, subject its affirmative vote to the additional condition of the states. Be admitted to membership in the United Nations together with the state. So, in summary, the General Assembly of the United States asked the court to give an advisory opinion on the question concerning the conditions of admission of a state to membership in the United Nations. So from the creation of the United Nations, some 12 states had unsuccessfully applied for admission. Their applications were rejected by the Security Council in consequence of a veto imposed by one or other states. So the court then analyzes Article 4, Paragraph 1 of the Charter. The conditions enumerated therein must have these five qualifications. It must be a state, peace loving, must accept the obligations of the charter, must be able to carry out these obligations, and must be willing to do so. So all these conditions are subject to the judgment of the organization of the Security Council and the General Assembly, and in the last resort of the members of the organization. So as the question relates not to the vote but to the to the reasons which members give before voting, it is concerned with the individual attitude of each member called upon to pronounce itself on the question of admission. So it is laid down for the admission of the states. It must be these conditions rather must be fulfilled by a state in which a candidate and the Security Council ought to make the recommendation which would enable the General Assembly to decide upon the admission. So that's it for the first advisory opinion. The second one is the reparation for injuries suffered in the service of the United Nations. So the issue in here, there are two issues actually. So first is in the event of an agent of the United Nations in the performance of his duty suffering injury in circumstances involving the responsibility of a state, has United Nations as an organization the capacity to bring an international claim against the responsible de jure or de facto government with a view to obtaining the reparation due in respect to the damage caused, letter A, to the United Nations, B, to the victim of, or to person entitled through him. Second, in the event of an affirmative reply on point one, how is action by United Nations to be reconciled with such rights as may be processed by the state which the victim is a national? So this advisory opinion was a consequence of the assassination in September 1948 in Jerusalem. So the United Nations and other members of the United Nations mission to Palestine, the General Assembly asked the court whether United Nations had the capacity to bring an international claims against the state responsible with a view obtaining a reparation of damage caused to the organization and to the victim. So in this advisory opinion, it followed that the organization had the capacity to bring a claim and to give it a character on an international action for the reparation of the damage that had been caused to it. The court ruled further that the organization can claim reparation not only in respect of damage caused to itself, but also in respect of damage suffered by the victim or persons entitled through him. So next is the competence of the General Assembly for the admission of a state to the United Nations. This is an advisory opinion of March 3, 1950. So this is the issue. Can the admission of a state to membership in the United States pursuant to Article 4 paragraph 2 of the charter be affected by a decision of the General Assembly when the Security Council has made no recommendation for admission by reason of the candidate failing to obtain the requisite majority of the negative vote of a permanent member upon a resolution to recommend? So the question basically is whether in the absence of recommendation by the council, the assembly could make a decision to admit a state. So it was ruled by the court that it is no doubt as to the meaning of the relevant clause, paragraph 2, article 4 of the charter. There are two things that is required. So number one, a recommendation by the council, and number two, a decision by the assembly. So the use in the article of the words recommendation and upon imply the idea that the recommendation was the foundation of the decision. Both these acts were indispensable from the judgment of the organization. So in consequence, it was impossible to admit that the assembly had the power to attribute to a vote of the Security Council the character of a recommendation when the council itself considered that no such recommendation had been made. So next is the interpretation of peace treaties with Bulgaria, Hungary, and Romania. This is the first phase. This is an advisory opinion of March 30, 1950. So there are actually four issues resolved in this case. So to sum it up, this is the decision of the court. So this case concerned the procedure to be adopted in regard to the settlement disputes between state signatories of peace treaties of 1947, the Bulgaria, Hungary, Romania on the land, and the allied states on the other. So the court stated that the countries which had signed a treaty providing an arbitral procedure for the settlement disputes relating to the interpretation or application of the treaty were under obligation to appoint their representatives to the arbitration commission prescribed by the treaty. Notwithstanding this advisory opinion, the three states which had declined to appoint their representatives on the arbitration commissions failed to modify their attitude. A time limit was given to them within which to comply with the obligation laid down in the treaties as they had been interpreted by the court. After the expiry of the time limit, the court was requested to say whether the Secretary General, who, by the terms of the treaties, was authorized to appoint the third member of the Arbitration Commission in the absence of agreement between the parties in respect of its appointment, could proceed to make this appointment, even if one of the parties had failed to appoint its representative. So that is it for the first part. I will give now the floor to Mr. Libera. Sir, kindly continue the report.
Thank you, Ma'am Yanong. This is a continuation of the advisory opinion of July 11th of July 1950, the international status of Southwest Africa. The court decided unanimously that the Southwest Africa was a territory under the international mandate assumed by the Union of South Africa on December 17, 1920 by 12 votes to 2 that the Union of South Africa continued to have the international obligation resulting from the mandates, including the obligations to submit reports and transmit petitions from the inhabitant of that territory, the supervisory functions to be exercised by the United Nations, and the reference to the Permanent Court of International Justice to be replaced by reference to the International Court of Justice in accordance with Article 7 of the Mandates and Article 37 of the Statute of the Court, unanimously that the provision of Chapter 12 of the Charter were applicable to the territory of Southwest Africa in the sense that they provided a means by which the territory may be brought under the trusteeship system. The second advisory opinion of 18th of July 1950 is the interpretation of peace treaties with Bulgaria, Hungary, and Romania, second phase. Though the diplomatic exchange between Bulgaria, Hungary, and Romania on one hand, and certain allied and associated powers signatories to the treaties of peace on the other, concerning the implementation of Article 2 of the treaties with Bulgaria and Hungary and Article 3 of the treaty with Romania, disclose dispute subject to the provision for the settlement of dispute contained in Article 36 of Treaty of Peace with Bulgaria, Article 40 of the Treaty of Peace with Hungary, and Article 38 of the Treaty of Peace with Romania. Number 2. Are the government of Bulgaria, Hungary, and Romania obligated to carry out the provision of the article referred to in question 1, including the provision for the appointment of the representative of the Treaty Commission in the event of an alternative reply to question 2, and if within 30 days from the date when the court delivers its opinion, the government concerned have not notified the Secretary General that they have appointed the representative to the Treaty Commissions, and the Secretary General has no advice advised the International Court of Justice. Number 3. If one fails to appoint a representative of a treaty commission under the treaties of peace with Bulgaria, Hungary, and Romania, where that party is obligated to appoint a representative to the treaty commission, is the Secretary General of the United Nations authorized to appoint the third member of the commission upon the request of the party to a dispute according to the provision of the respective treaties? Number 4. Would a treaty commission composed of a representative of one party and a third member appointed by the General Secretary of the United Nations constitute a 14th commission within the meaning of the relevant treaties articles competent to make a definitive binding decision in settlement of a dispute? Number, the court had declared in its opinion of March 30th that the government of Bulgaria, Hungary, and Romania were under an obligation to appoint their representative to the treaty commissions. Refusal to fulfill a treaty obligation would involve international responsibility. Nevertheless, such a refusal could not alter the condition contemplated in the treaty for the exercise of the Secretary General's power of appointment. These conditions were not present in this case, and their lack was not supplied by the fact that their absence was due to the breach of a treaty obligation. The failure of machinery for settling disputes by reason of the practical impossibility of creating the commission provided for the treaties was one thing, international responsibility another. One could not remedy the breach of a treaty obligation by creating a commission which was not the kind of commission contemplated by the treaty. It was the court's duty to interpret treaties, not to revise them. Nor could the principle that a clause must be interpreted so as to give it practical effect justify the court in attributing to the provisions a meaning which would be contrary to the letter and spirit. The fact that an arbitration commission may make a valid decision although the original number of its member is later reduced, for instance, by withdrawal of one of the arbitrators, did not permit drawing an analogy with the case of appointment of a third member of the Secretary General in circumstances other than those contemplated in the treaties, because this raised precisely the question of initial validity of the constitution of the Commission. The third advisory opinion of 28th of May 1951, the reservations to the conventions on the preservation and punishment of a crime of genocide. The question concerning reservations to the Convention on the Prevention and Punishment of Crime of Genocide have been referred for an advisory opinion to the Court by General Assembly of the United Nations. GEG Resolution of November 5, 1950 in the following terms: insofar as concerned the Convention on the Prevention and Punishment of a Crime of Genocide, in the event of a state ratifying or acceding to the convention subject to a reservation made either on ratification or on accession or on signatures followed by ratification. First question. First, can the reserving state be regarded as being party to the convention while still maintaining its reservation if the reservation is objected to by one or more of the parties to the convention but not by others? Number two, if the answer to question 1 is in affirmative, what is the effect of the reservation as between the reserving state and A, the party which object to the reservation, B, those which accept it? Number 3, what would be the legal effect as regards the answer to question 1 if an objection to a reservation is made by A, by a signatory which has not yet ratified, B, by a state entitled to sign or accede but which has not yet done so? In November 1950, the General Assembly asked the Court of series of questions as to the possession of a state which attached reservations to its signature of the Multilateral Convention on Genocide if other states' signature of the same convention objected to this reservation. The Court considered in its advisory opinion of 28 of May 1951 that even if the convention contained no article on the subject of reservations, it did not follow that they were prohibited. The character of the convention, its purposes, and its provision must be taken into account. It was the compatibility of the reservation with the purpose of the convention which must furnish the criterion of the attitude of the state making the reservation and of the state which objected thereto. The court did not consider that it was possible to give an absolute answer to the abstract question put to it. As regards the effects of the reservation in relation between states, the court considered that a state could not be bound by reservation to which it had not consented. Every state was therefore free to decide for itself whether the state which formulated the reservation was or was not a party to the convention. The situation presented real disadvantages, but they could not only be remedied by the insertion in the convention of an article on the use of reservation. A third question referred to the effects of the objection of the state, which was not yet a party to the convention, either because it had not signed it or because it had signed it but not ratified it. The court was of the opinion that as regards the first case, it would be inconceivable that a state which had not signed the convention should be able to exclude another state from it. In the second case, the situation was different. The objection was valid, but it would not produce an immediate legal effect. It would merely express and proclaim the attitude which a signatory state would assume when it had become a party to the convention. In all the foregoing, the court adjudicated only on the specific case referred to it, namely the Genocide Convention. The fourth advisory opinion was on July, 13th of July 1954. The effects of awards of convention made by United Nations Administrative Tribunal. The question concerning lie effects of awards of compensation made by United Nations Administrative Tribunal had been submitted for an advisory opinion to the court by the General Assembly of the United Nations, which on December 19, 1953 adopted the following resolution for this purpose. The General Assembly, considering the request for a supplementary appropriation of $179,420 made by Secretary General in his report A/2454 for the purpose of covering the awards made by the United Nations Administrative Tribunal in 11 cases, number 26 and 37 to 46 inclusive. Considering the concurrence in that appropriation by the Advisory Committee on Administrative and Budgetary Questions contained in its 24th report to the 8th session of the General Assembly, A 2580, considering nevertheless that important legal questions have been raised in the course of debate in the Fifth Committee with respect to that appropriation, decide to submit the following legal questions to the International Court of Justice for an advisory opinion. Having regard to the statute of the United Nations Administrative Tribunal and to any other relevant instrument and to the relevant records, has the General Assembly the right on any grounds to refuse to give effect of an award of compensation made by the tribunal in favor of a staff member of the United States whose contract of service had been terminated without his assent. Number two, if the answer given by the court of question 1 is affirmative, what are the principal grounds upon which the General Assembly could lawfully exercise such right? The court had given an opportunity to the member of the United Nations and to the International Labour Organization to submit their views on this matter. To the first question, the court replied that the General Assembly has not the right on any grounds to refuse to give effects on an award of a compensation made by the Administrative Tribunal of the United Nations in favor of the staff of the United Nations whose contract of service has been terminated without his assent. In its opinion, the court begins by analyzing the first of the questions submitted to it. This question, which is general and abstract, is strictly limited in scope. If one compares its terms with those of the statute of the tribunal, it is clear that it concerns only awards made by the tribunal within the limits of its statutory competence. It is moreover clear from the documents submitted to the court that it contemplates only awards made by a properly constituted tribunal. Lastly, it relates solely to awards made by the tribunal in favor of staff member whose contract of service have been terminated without their assent. Okay, that's all. May I give the floor to Shara Milanshan to continue the report.
So, thank you, Mr. Libera. So, let us proceed to the next advisory opinion. So, this was promulgated on June 7, 1955, entitled Voting Procedure on Questions Relating to Reports and Petitions Concerning the Territory of Southwest Africa. So, the overview of this case. So, following the preceding opinion of the General Assembly concerning the international status of South Africa on October 1954, adopted a special rule on voting procedure to be followed by the Assembly in taking decisions on questions relating on reports and petitions concerning the territory of West Africa, Southwest Africa. So, according to this rule, such decisions were to be regarded as important questions within the meaning of Article 18, Paragraph 2 of United Nations Charter and would therefore require a two-thirds majority of members of the United Nations present and voting. So basically, the General Assembly of the United Nations, by resolution adopted at its plenary meeting in connection with its consideration of the question of Southwest Africa, deciding to request the International Court of Justice to give an advisory opinion on the following questions. So, first question is the following rule on the voting procedure to be followed by the General Assembly a correct interpretation of the advisory opinion of the International Court of Justice? And the second one is, if this interpretation of the advisory opinion of the court is not correct, what voting procedure should be followed by the General Assembly in taking decisions on questions relating to reports and petitions concerning the territory of Southwest Africa? So the International Court of Justice said that the court therefore considers the Rule F recited in question A is in accord with the passage contained in the court's previous opinion, namely that the degree of supervision to be exercised by the General Assembly should not exceed that which applied under the mandate system and should conform as far as possible to the procedure followed in this respect by the Council of the League of Nations. So accordingly, the court concludes that the Rule F corresponds to a correct interpretation of its advisory opinion of 1950. The court is unanimously of opinion with regard to question A that the said rule is a correct interpretation of the advisory opinion of the July 11th, 1950 opinion. So, such being the case, it follows that the General Assembly, in adopting a method of reaching decisions in respect of the annual reports and petitions concerning Southwest Africa, should base itself exclusively on the Charter. So, Article 18 of the Charter authorizes the General Assembly to decide whether the decisions of this nature involve important questions or other questions. So the General Assembly has concluded the decisions by it on questions relating to reports and petitions. So moving forward, the next advisory opinion, this was promulgated on June 1, 1956, entitled Admissibility of Hearings of Petitioners by the Committee on Southwest Africa. So the overview of this case, in this advisory opinion, the court considered that it would be in accordance with its advisory opinion of 1950 on the international status of Southwest Africa for the Committee on Southwest Africa, established by the General Assembly to grant oral hearings to petitioners on matters relating to the territory of Southwest Africa, if such a course was necessary for the maintenance of effective international supervision of the mandated territory. So the General Assembly was legally qualified to carry out an effective and adequate supervision of the administration of the mandated territory. So the question here is basically the General Assembly of the United Nations by resolution adopted at its plenary meeting in connection with its consideration of the question of Southwest Africa, deciding to request the International Court of Justice to give an advisory opinion on the following question. So, is it consistent with the advisory opinion of the International Court of Justice of July 11, 1950 for the Committee on Southwest Africa, established by General Assembly Resolution 749A of November 28, 1953, to grant oral hearings to petitioners on matters relating to the territory of Southwest Africa? So, the International Court of Justice, by its advisory opinion, states that the particular reason or the particular question which has been submitted to the court arose out of a situation in which the mandatory has maintained its refusal to assist in giving effect to the opinion of July 11, 1950, and to cooperate with the United Nations by the submission of reports and by the transmission of petitions in conformity with the procedure of the mandate system. This sort of situation was provided for by the statement in the court's opinion of 1950 that the degree of supervision to be exercised by the General Assembly should conform as far as possible to the procedure followed in this respect by the Council of the League of Nations. So the court holds that it would not be inconsistent with its opinion of July 11, 1950 for the General Assembly to authorize a procedure for the grant of oral hearings by the Committee on Southwest Africa to petitioners who had already submitted written petitions, provided that the General Assembly was satisfied that such a course was necessary for the maintenance of effective international supervision of the administration of the mandated territory. So the court is of opinion that the grant of oral hearings to the petitioners by the Committee on Southwest Africa would be consistent with the advisory opinion of the court promulgated on July 11, 1950. The opinion of the court of July 11, 1950 is that the paramount purpose underlying the taking over by the General Assembly of the United Nations of the supervisory functions in respect of the mandate for the Southwest Africa formerly exercised by the Council of the League of Nations, was to basically to safeguard the sacred trust of civilization through the maintenance of effective international supervision of the administration of the mandated territory. So accordingly, in interpreting any particular sentences in the opinion of the court of July 11, 1950, it is not permissible in the absence of express words to the contrary to attribute to them a meaning which would not be in conformity with this paramount purpose or with the operative part of that opinion. So, so let us proceed to the next advisory opinion. So this was promulgated on October 23, 1956, entitled Judgments of the Administrative Tribunal of the ILO upon complaints made against UNESCO. So the overview of this case, so the statute of the Administrative Tribunal of the International Labor Organization, or the ILO, provides that the tribunal's judgments shall be final and without appeal, subject to the right of the organization to challenge them. It further provides that in the event of such a challenge, the question of the validity of the decision shall be referred to the court for an advisory opinion, which will be binding. When four UNESCO staff members holding fixed-term appointments complained of the Director General's refusal to renew their contracts on expiry, the tribunal gave judgment in their favor. So the UNESCO challenged these judgments, contending that the staff members concerned had no legal right to such renewal and that the tribunal was competent only to hear complaints alleging non-observance of terms of appointments or staff regulations. So basically, the Executive Board of the United Nations Educational, Scientific, and Cultural Organization, by resolution, acting within the framework of Article 12 of the Statute of the Administrative Tribunal of the International Labor Organization, decided to challenge the decisions rendered by the tribunal in Leff, Duberg, and Wilcox cases, also in the Bernstein case, and to refer the question of their validity to the International Court of Justice. The question here is, was the administrative tribunal competent under Article 2 of its statute to hear the complaints introduced against the United Nations Educational, Scientific, and Cultural Organization? So the International Court of Justice said that in its opinion, the court noted that the facts were essentially the same in all four cases and referred solely to the case of Mr. Peter Duberg. He had a fixed-term appointment with UNESCO, which was due to expire on December 31st of 1954. So the court noted that before the tribunal, both the complaints and UNESCO had placed themselves on the ground of the provisions of the staff regulations. Within those terms, the administrative memorandum of July 6 also fell. So in the view of the court that the memorandum constituted a modification of the staff rules which the Director General was authorized to make under the staff regulations. It also referred expressly or by implication to the text of the staff regulations and in particular to the notion of integrity around which centered the controversy submitted to the administrative tribunal. So accordingly, whether looked at from the point of view of non-observance of the terms of appointment or of that of non-observance of staff regulations, the complaints had a legitimate ground for complaint and the tribunal was justified in confirming its jurisdiction. So the next advisory opinion, dated June 8, 1960, Constitution of the Maritime Safety Committee of the Intergovernmental Maritime Consultative Organization. So the overview, under the terms of Article 28, Paragraph A of the Convention for the Establishment of the Organization, this committee consists of 14 members elected by the Assembly from the members of the organization having an important interest in the maritime safety, of which not less than 8 shall be the largest ship-owning nations. When on January 15, 1959, the IMCO Assembly, for the first time, proceeded to elect their members of the committee. So it elected neither Liberia nor Panama, although those two states were among the 8 members of the organization, which possessed the largest registered tonnage. Subsequently, the Assembly decided to ask the court whether the Maritime Safety Committee had been constituted in accordance with the convention for the establishment of the organization. In its advisory opinion of June 8, 1960, the court replied to this question in the negative. So the question here is, has the Assembly, in not electing Liberia and Panama to Maritime Safety Committee, exercised its electoral power in a manner in accordance with the provisions of Article 28A of the Convention of March 6, 1954 for the establishment of the Intergovernmental Maritime Consultative Organization? So in this case, the court could not subscribe to an interpretation which would empower the assembly to refuse the membership of the committee to a state, regardless of the fact that it ranked among the first 8 in terms of registered tonnage. Consequently, in electing neither Liberia nor Panama, which were included among the 8, the assembly had failed to comply with the Article 28, paragraph A of the convention. So the court finally observed that its interpretation of Article 28, paragraph A was consistent with the general purpose of the convention and the special functions of the objective test of any kind. The structure built into the article to ensure their predominance on the committee would collapse. It was apparent that some basis of measurement must be applied. The largest ship-owning nations were to be elected on the strength of their tonnage. So the last assigned advisory opinion, this was promulgated on July 20, 1962, entitled Certain Expenses of the United Nations, Article 17, Paragraph 2 of the Charter. So, Article 17, Paragraph 2 of the Charter of the United Nations provides that the expenses of the organization shall be borne by the members as apportioned by the General Assembly. So on December 20, 1961, the General Assembly adopted a resolution requesting an advisory opinion on whether the expenditures authorized by it relating to the United Nations operations in the Congo and to the operations of the United Nations Emergency Force in the Middle East constituted expenses of the organization within the meaning of this article of the Charter. So basically, the question here is that, do the expenditures authorized in General Assembly's specific resolutions constitute expenses of the organization within the meaning or within the purview of Article 17, Paragraph 2 of the Charter of the United Nations? So the International Court of Justice said that the text of Article 17, Paragraph 2 referred to the expenses of the organization without any further explicit definition. The interpretation of the word expenses had been linked with the word budget in Paragraph 1 of the article, and it had been contended that in most cases, the qualifying adjective regular or administrative should be understood to be implied. So according to the court, this would be possible only if such qualification must necessarily be implied from the provisions of the Charter considered as a whole. So turning to paragraph 2 of Article 17, the court observed that on its face, the term expenses of the organization meant all the expenses and not just certain types of expenses, which might be referred to as regular expenses. So the court did not perceive any basis for challenging the legality of the settled practice of including such expenses in the budgetary amounts which the General Assembly apportioned among the members in accordance with the authority which was given to it by Article 17, Paragraph 2. So that would be all. I hope you guys have uh, learned something about our discussion today, and you can also um, correlate it to the notes that we are going to give you. So thank you very much, and thank you for watching.